So our next session is an expert talk keynote, from idea to patent. Starting your patenting adventure, discover the essentials of turning innovative ideas into patent with Sarika Sinha, a thought leader in intellectual property rights. So I call upon Sarika Sinha. Please put your hands together for Sarika Sinha. Thank you.
Hello everyone. Can everyone hear me? Okay, great. Great to see you all. Welcome to understand what is patenting. How can we actually, everyone knows that necessity drives innovation. But when do you feel it is necessary? That's the most important thing. We generally accept, right? Okay, it works like this, and that's where our creativity stops, right? How then we can innovate only if we feel the need of it, we give it a importance, right? So I'm Sarika Sinha, and I'm a senior engineering manager with IBM System Lab, right? And we'll like to present this idea to you all so that you understand how I went through this, how I started, and then understanding the basics of patent. And yeah, let us try to start everyone's journey from here. Okay, so I have 12 patents and 4 in preparation. We will later understand what does in preparation mean, right, when we go into the details about the phases of the patent, right? So, so innovation, the patent is one aspect of the innovation. It doesn't end with that. Not everyone will thrive for it to be a patent, but still I will say everyone should be innovative. In every aspect of our life, whatever we do, how we do, that also matters a lot, right? So I try to drive innovation through different roles. I participate, right, as an engineering lead, as an open source Eclipse platform co-lead, and also a guild leader where I try to, as everyone knows, generative AI and cloud is the most asked upon things. How to train people, how to know the things, where we can infuse AI. It's not only about understanding AI, but how can we infuse to increase our productivity or build up a case where, how can we avoid the mundane tasks which a system can do, right? And as IBM has, because of these inventions and the way I mentor the inventors community, IBM has recognized me with a master inventor designation. And through that, I try to motivate. I work with inventors very closely so that they come up with the ideas to shape up it into a patent. Is this a valid scenario for a patent or not, right? So those are the things I try to work with them. I also review their inventions, what they are trying to build up, right? And definitely I try to share my knowledge through different international and domestic conferences so that we can spread the thought of innovation, try to be creative, how can we work towards that? Okay, so this is how a different process. We will go to the each part in detail, right? From where does it start with the brainstorming, with the thoughts, how idea can be thought through, different aspects of the idea, what do we want to pursue it as a patent, how we drive the claims. Every patent will have claims as to what is this, the novel feature, what we are bringing up as a new thing to the world, right? And then definitely it costs money, it costs effort, right? So there has to be a strategic vision as to what are the things which as a personal or a corporate, whoever is trying to make it as a patent, why do we want to have it as a patent? What is the goal of it? right? And then there is preparation part, and then we file it to a particular patent office, and then there is a review board of the patent office which reviews it, and then they decide whether it's a valid patent or not, right? So we will go through each of the aspects of the patent journey. Right? So first, I know everyone knows the word patent, but what does it mean to have the patent? There are various things, right? Like there is copyright, there is a trade of secret, there is a patent, right? So there are a little subtle differences in all of these. So copyright is more for a tangible kind of a thing, like the code or a song, a video, right? So those are the things where we can say it's a copyright. Those are also granted by the government, but patent is also granted by the government, but it is more of a, there are different types of patents, and what are the privileges you get by having it granted by a particular patent office. So there is a US patent office, there is also different for the European. So depending on where your business is, what is the target of your patent, you will try to have that invention patented for that particular region. What will that mean? That will mean that no one else can sell your invention in that particular area, right? Do you get the right to sell automatically? May or maybe not, because there might be some other restrictions, acts, and you might have to take other permissions as well. But you have the right to go ahead and start working on it, and if with all those approvals, you can sell it in that particular region. So the main target is to restrict the infringement so that no one else, right? It gives us a right of exclusivity. Unless and until we allow that, okay, anyone else can use it, no one else can use it, right? So that's the main purpose of that. And these patents, we think that it is for whole life, but no, it is for only 20 years validity, because what they think is after 20 years, it actually becomes so much public and everyone knows about that, so there is no exclusivity right required for further things. But trade secret is a different thing. Anyone knows about any example of trade secret? Coca-Cola, yes. Everyone remembers the Coca-Cola, right? What is the mix of that Coca-Cola? And no one. So trade secret is a secret till it is not known to people. So it's for a lifetime, but if it leaks, it's gone, right? So what is the masala mix used? So that has to be, so they actually, the trade secrets are literally, put it in the lockers or different type of restrictions so that it should not be known to everyone, right? But patent is not like that. Patent will be actually open. The whole description about it will be known to everyone, but you can't use that. So that's why for patent it is also important that it should not be hidden. It should be easily discoverable that this patent was used. Otherwise, infringement cannot be tracked. If it is very deep inside, it will be very difficult to find out that this patent was used or not, right? Okay, so to understand, a very high level of different types of patent, we have utility, design, and the plant. Going from the down, plant is more about the new plants and all, which is not, I will not go into those details. Design is more a design which is very much associated to an object, like going back to Coca-Cola, the bottle design of the Coca-Cola, right? So that is a design part of it, which cannot be actually separated from the object. So what we deal normally with is the utility patent, right? Utility patents also has, different, so it can be a different process, a machine, right? Or even a new chemical composition. So these are the main patents, and what we generally talk about, we can classify it to be a utility patent. Okay, so why? Why anyone goes for a patent? Why is it important, right? So exclusivity, as I spoke about, that only I will have the permission to deploy it, sell it, use it in my product. No one else can use it. Then there is a portfolio management, right? People want to, suppose there is a company who is working on a particular vertical, right? Suppose they are doing something in the cloud domain, in or AI domain. They want to build the portfolio. So what will they do is, they will try to have more innovations around that. Why this is important? So these are important for several business decisions, right? When acquisition and mergers happen, it is the patent portfolio which actually drives a very big amount of the deal money, because the number of patents you have, that actually amounts, how much earnings you can get. Because so then I come to licensing and IP income. So I got the exclusivity, but I still have an option to rent it out, right? Okay, you can use, I have found a new thing, it has been patented by the office, but someone wants to use it, they can get a license to use, but they will have to pay for it, right? So there's a lot of licensing amount. There is it can be transferred as well during these acquisitions and mergers, right? So a lot of money is involved with the patenting, and that's why I said we'll go it in a later more detail, the strategic part of it, right? Because it costs money. It is not very cheap to own a patent, right? So you have to put money and effort. You will want to, as a business, why will you want to spend money where you are not going to? So there should be ROI, right? Everyone works towards they should get something in return, right? So again, obviously there is a brand value, there are values, right? Okay, so this particular company has, or this particular person, so it gives that brand value, the recognition, the reputation, right? So we always say, okay, so in the last decade, which company, so every year the report will come that which company actually had the most number of patents filed, right? Then it will be, okay, in this domain. So that's how we say, okay, who is the new AI leader? Who is the new cloud leader? How do we go? So it's not only about the work done, but also who is innovating in that particular area or in general. So it's a reputation and the brand. So also like license on transfer. So one thing was just to do the license, and one thing is to transfer, if I just give the exclusivity right to others. So these are the different things. And what is the, why patent is for two main reasons. One is offensive and one is defensive. Offensive is, I am planning to go bang on this particular domain, and I want, right, that I should build my portfolio in that particular domain. No one else should, I want others to be left behind rather, right? That is my idea. So I go for those particular ideas as a patent where I want to build my portfolio and reputation. Sometime we go for defensive, so that if we are, if there is a possibility that someone can have someone can actually go against us that, okay, you did not have this right, and why did you go? So to protect ourselves, right? So to defend ourselves rather, so it is not in my portfolio business. I am not actually in that particular domain, but I don't want to get into any legal problem, so I go as a defensive action, right? Okay, so now I will try to, just, there are so many myths, right? So I will try to take care of the major myths what people have, right? So what we think is, so suppose in technical, I don't code, but I am, a quality analyst person. I am a content writer. And I don't think I can do this, right? It's not, I'm not inventing something new. How can I have a patent, right? People give up at that stage. No, no, no. I am not doing anything, something great which can lead to a patent. No. So please first stop thinking like that. Anyone doing anything actually can think of improvising the process, right? It's about don't accept the process as is. Try to see, okay, what if this would have had a different kind of a, path, and that would have been beneficial for me or for any other person? Think from that angle all the time, that how can you, break the normal norm, and but so so we will discuss later as to not all the ideas can be patented. That we will go in later. But first thing is, think about don't accept the process, right? Any process, even if it is a content writing or it's a testing. If you will go to patents.google.com, you will see multiple ideas on testing. How do you test any particular thing? You can have innovation in that, right? So don't shy away from this word patenting if you are not into coding, or if you if you have that. It's a mindset which drives the innovation, not the act. Any act can be improvised for ourselves or for others, right? And that, see, that's why I'm saying lot of technical skills. It's not required to be, that you have to go into the detail, because we don't have to develop a model or a prototype, right? What we have to do is we have to build a use case, and how we do have to say that how possibly it will work in one of the scenarios, but we don't have to actually develop a prototype to get a patent. That is not the request, right? Again, but only idea is not sufficient. You need to back it up with some feasible solution which is existing now. You can't say, okay, if this will happen, then my patent. So then, unless and until you develop that or someone develops that, you can't have that as a patent. So only idea is not the requirement. We will go through the detail, what all is there in a patent, right? But not the only idea. We do have to work towards some of the details and think about it as to how will it be implemented, but actually not implement, okay? Okay, so how to think about, I got an idea. Oh, so you have to have your eyes and ears open. That is the first criteria of, getting the ideas. Whatever you are doing with, it's not necessary that, you might be just traveling and you see something and you see, oh, if this would have been like this, why it would have helped me so much. It would have helped, if it's not me, maybe it would have helped the ambulance going, or the police monitoring, anything, right? So first, it has to be an idea which is a new, right? Innovative, novel. So it has to be a new thing. It should not have existed. But remember, sometimes what we think is, many people see, Okay, many people see, but they don't understand that if this added to this, actually it might solve a very big problem, right? So it is not always making a rocket as a patent, we need to understand. It's kind of sometimes mixing things, right? When we can mix, but it actually then creates a new thing. So it's not like in chemistry also, right? There are new things, but if you make a new thing and the properties changes, so does the property change or no, it was a obvious? So like non-obvious is also a very big criteria, that it should not, the characteristics remains the same and we know, okay, after this will happen. No. Obviously with the combination of those things, it should impact some of the normal path, right? And definitely it has to be valuable to someone, right? It may or may not be valuable to you. When we are going, if we are part of any corporate and it is going via corporate, obviously corporate will see that are they working in that portfolio, are they valuable to it, or for offensive or defensive, right? Any case, is it valuable to them? So value definitely, why will you put an effort? It is for some value in some form, right? Then the important part is, how is less important than, how is important, not what. So that's why I was saying, like, how do you plug in things? How do you make things together? That is not only what is there, but how did you arrive at that? That is very important part of the idea to patent. When we say we need to have the implementation as also, that how did you arrive at that point, right? But there are few things which might, see, sometimes we write a code, okay, no, this is, a unique way of doing it. But like algorithms and all, or if it is, a very common, valuable thing across the world, are going against that. Suppose you think, okay, no, this is against, you are proposing something which is like against the law of gravity. Just giving an example. If it has to be at that kind of a level, first the law of gravity has to be, against that should be proven. Then only you can back it up. So the, or what we are thinking as a mental, these things cannot be patented, right? A computer code actually cannot be patented, but the approach, how these building parts were associated to do that, you build those blocks, those can be patented. That what did I do in the computer code? If you break it into different parts, so this was evaluated, that was evaluated, those things can be done, but not the actual computer code is not patentable, right? So as I said, so design is a different thing when we associate it to a project, but in general, the aesthetics and those things are not, and if it goes against, like moral behaviors, which is, so like IBM stands very strong that it will not go for any inventions which is going to, put, like even for artificial intelligence or for patent, it will not have anything related to which can harm a person, or it can break the common expectations of either the, even the inclusivity, or if it can be it can show a biased behavior on anything, right? So those things are actually not patented again, right? Okay, so now, okay, we have the idea, we think it is valuable, we think it is implementable. Now what do we do about that? So what are the things, so if you, I don't know how many of you have actually seen any patent document. It's very difficult to understand that, right? It's not a easy language to understand. So when we write the application to the patent office, definitely all single person individually is not capable of, right? Because there is a legal language attached to that also. So when we say a computer, it cannot be just computer. There are certain ways, you have to do that. And that's where we will come later as where we have these attorneys which are specifically for patent, who will make it, in an acceptable form, which is generally understood by a patent office in a very detailed manner. But for them to be able to write it up and develop it, what do we have to give, right? Those tasks are very specific tasks, and it's okay don't get worried that I can't write that. But there are people, we have patent attorneys who can build that. So that's a second part. See, that is required for anything. We don't construct a house, we don't know it, but we will have a plan, how do we do that? But real execution, the designer will do that. So, but you need to describe the problem. First, the problem should be you need to have a very clear problem. This is currently not there, right? And I face this problem when I do this. So that is the use case. Okay, when I do these things, I don't see it and I get into these problems, right? So problem. Why brainstorming is required? Because for a same problem, there will be various aspects to it. Again, not every aspect can be patented, right? So you need to think how that problem, which aspect of it can be patented, and how can that actually help me to, save it to be used by others. Few things will be obvious. What is the non-obvious part of it? So that is a very big thinking we have to do. And these things generally, doing it alone is, I will say, very difficult. It is good to have people you can talk to, because you might miss many things from a different perspective. So it's good to talk about your problem, brainstorm it with people, get the various obvious, non-obvious part of it, and what can be patented. And then drive the claims. Okay, so now I have these non-obvious items. I think that these things are not there right now in the world, and I can claim these things as a novel item, right? Then I describe that, okay, these things are not there, and I build, okay, having these as a patented, this will solve these use cases. And then I need to describe it in a little detailed manner as to what will that, invention, that solution. So this detailed description is about a possible solution, that how I am going to solve this problem which solves this use case, right? Adding drawings always help, right? For the patent reviewers as well as for the attorney to understand what you are saying, where are these objects and the building blocks lying, how are they connected, right? Now, once all these things are there, right? So now we select which patent office I want to go to. Where should I apply for this, right? So this patent, if I want to restrict the selling in US, I will go to, so most common is USPTO, definitely everyone hears more about. So everyone does file in USPTO, but many people will additionally file it in Europe also, if there is a big market over there for those things. So because USPTO will just restrict the selling of it in US, right? So you need to decide based on your strategy that where are you going to restrict. So accordingly, you will choose the patent office, and then, as I said, patent attorney, you need to get to a legal person which can put your description, drawings in a legal language which patent office understands and which meets the requirement of the patent office, right? So as I said, it is costly, right? So fees is an important part of it. There are different categories, right? Fees, first fees is to just apply for it, right? And then you have to also, for 20 years, you don't get, by paying just one time, you have to pay again 4 years, 8 years, 12 years. You have to pay the maintenance fees, okay? So these are the important part of the fees. Sometimes people file it just as a provisional. We can keep it as a provisional for a year. Suppose you don't have enough detail and description and you just want to protect it right now, because if you don't file it, someone else can file before and then you lose the rights. So you file it as a provisional, and then within 1 year you can just complete all the details. And then there will be a review. Once you file that, it takes generally 2 years. It's very long time, right? The PTO offices are very loaded. It takes around 2 years, right, to decide whether it's granted. That means it's approved. It has become a patent. It can be rejected. They can ask for some correction, clarification, and it can be amended a little bit to just, describe a claim or to add the clarification little bit. You can't just change the whole thing, but you can do some minor amendments which does not change the main claim, right? And as I already told about the maintenance, we don't get it directly for 20 years. We have to maintain it. If we don't give that fees, it will be again expire. And so then we get it for 20 years, we have it, right? Okay, so that's it about it. Thank you everyone for listening through it. And yeah, if anyone wants to know further, I'm not sure we have the time, or I'll be here. So you can reach out to me, or you can reach out to me on the LinkedIn or on patents.google.com. You can search by Sarika Sinha. You can see the patents which has already been filed, and it will show up, right? Thank you all.
So thank you so much, ma'am, for the informative session. I call upon Arushi from anadabi.org to present a token of appreciation from our side, please.
Thank you. Thank you. Yeah. Yes. Thank you.